Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5205. KalshiEX LLC versus Commodity Futures Trading Commission, appellants. Mr. Schwartz for the appellant, Mr. Roth for the appellee.
Good morning, Your Honors. Rob Schwartz on behalf of the CFTC. The district court granted summary judgment in favor of the plaintiffs, Kalshi, based on what my friends call an event-focused reading of the statute, which for the sake of brevity, I'll call Section 5C. We're asking the court to apply a text-focused reading of the statute and to vacate summary judgment and remand for further proceedings. To build and maintain a thriving derivatives industry that is distinct from the gambling business has been the work of 175 years, and it's important. The statute, Section 5C, is a part of that, and the reason we're here today is because a federally regulated exchange has turned itself into an online casino for betting on elections. The question for the court, though, is not whether that's right or wrong, but whether the CFTC can even evaluate that activity. The text of Section 5C clearly says that we can. It says that the commission may review agreements, contracts, or transactions that are based on an event if the agreements, contracts, or transactions involve one of a list of activities, including gaming or activity that violates state law. The election contracts qualify if you consider them as a whole, like the statute says, rather than focusing on one isolated feature that has no basis in the text, as Kalshi wants. I'm going to offer the court three propositions. First, on what it means for an agreement, contract, or transaction to involve an activity. The parties agree on what the word involve means, that it covers a range of relationships, and that it keeps its ordinary meaning in Section 5C. That ought to be the end of the matter. But what Kalshi argues is they are not asking for a different meaning of the word involve. They're asking for a different reading of the word involve. Proposition number one is that those are the same thing, and there is simply no way to read this sentence the way that Kalshi is asking the court to apply it. Second, on gaming. Kalshi knows it can't confine gaming to betting on things that are called games, otherwise you miss things like fights and races. So what they've done is they've come up with a definition by which the gaming is something done for diversion or amusement and that serves no commercial purpose. Proposition number two is that their line is arbitrary and unworkable, and the commission has to analyze the economics of the contract at the second step in the public interest analysis. So in context, the word gaming makes a lot more sense here if it's understood to include, as a gatekeeping matter, things like betting on contests, with the understanding that the commission still has to evaluate the economics of the contract at step two.
Mr. Schwartz, I'm interested here. So in addition to the list of things that the CFTC can regulate, including gaming, it can regulate, it can use its authority to reach similar activity determined by the commission by rule or regulation to be contrary to the public interest. So could the commission have used that authority to do a general rulemaking to prohibit this type of, the type of contracts that Kalshi has?
Yes, but some context is important there. We discuss in our briefs.
And why hasn't it? You know, because then they don't have to sort of wedge it into gaming.
Right. We discuss in our briefs a 2012 order about an exchange called Nadex, in which the commission made the same holdings, if you will, about congressional control contracts. And then it was a settled issue for a decade. Nobody tried to do this again until Kalshi arrived. And now we're in a bit of a difficulty because the district court whiffed on what the meaning of involve is. So we would have to contend with that in a rulemaking. The commission proposed one, but at this point, we need the district court reversed in order to move forward. I believe that there is a path forward on rulemaking, but the district court really threw a wrench by misinterpreting what the word involve means.
If we concluded that the commission can't regulate this as gaming, I mean, if we were to conclude that, would that foreclose the commission's ability to promulgate a rule that this was a similar activity to gaming? Because if it's not gaming itself, could it be a similar activity to gaming?
Yes, it could be a similar activity to gaming.
Even if it's not gaming?
Even if it's not gaming, because the purpose of this is that the function of the contracts is gaming. The function of the contracts would be betting on elections in much the same way. So, and this is phrased various ways in the briefs and in the order, but that's the bottom line. If it were determined to be a similar activity because of those similarities, and they have a lot of line drawing problems here in between things that they admit are gaming and things that they claim are absolutely not gaming. So, for example,
the district court found that you have the biggest line drawing problem, which is that if gaming really does mean gambling, as you've defined it, then basically every event contract would fall within the special rule, not just certain ones.
right, that was incorrect because the commission cited a variety of sources, including dictionaries, that have broad definitions, but that is not what the commission relied on in this case. The commission held specifically that these contracts are gaming because they involve betting on a contest of others. That's the holding. So the fact that there may be hypothetical contracts possible that would be within a dictionary definition of gaming is not relevant to the question before the court today.
Well, you say that the definition of gaming is betting or wagering on a contest of others. Is that your definition?
It includes betting and wagering on a contest of others, but the commission did not promulgate, as though it were a legislative regulation, the commission did not promulgate a rule defining the outer bounds of what it means, of what these terms mean, and it didn't have to. I mean, that's just basic APA. Agencies should not do things like that. If you're going to issue a comprehensive scheme for regulating something, you're supposed to put it out for notice and comment. We have a requirement to do cost-benefit analysis. So what the commission did was to consider the facts before it and nothing more. And I do want to point out that they've been saying something that's not true about the order. They've been saying that the commission defines gaming to mean betting on contests and nothing more. The commission did not do that, and I expect that there are other things that may fit the bill. I'm not here to announce any kind of new policy on the part of the commission, but if it were a game, even if it were a one-player game, I think the commission would have a strong argument that a contract on that smart kid in Oklahoma, will he clear 2,000 lines at Tetris, was a gaming contract. That would be something they would look at the time, but it's absolutely not true that the commission defined gaming to mean betting on contests and nothing more.
So if you look at the statute defining event contracts under the special rule, it has it says that they're agreements, contracts, transactions, or swaps in excluded commodities. So by definition, all of these things are excluded commodities, right?
Correct.
Does the definition of excluded commodities help us at all? Recall that that definition is an event that's beyond the control of the parties to the contract and that has financial, commercial, or economic consequence?
Yes, I think it puts these events squarely within the definition of excluded commodity, but then of course the commission has to go on to apply these individual.
So then it goes on to say it involves, and then there's Roman 1 through 6, and 6 is the one that says other similar activity, which isn't an issue here because that requires a separate rulemaking or action that didn't happen. But it seems to me that 6 is relevant because it says other similar activity, meaning that Congress must have thought that there was some way that that we would be able to discern what is similar to items 1 through 5. That there must be some characteristic that is common in 1 through 5 that we can identify and discern, and then then we would know what would be similar activity to that. So what is that?
What is similar
What
activity?
is that characteristic?
Yeah.
That makes 1, 2, 3, 4, and 5 similar to each other, and that we could latch on to determine what else is similar to them.
Yeah, I mean, it could be similar to any of the enumerated activities. So if it's similar to war, it could be, which is kind of hard to define, but it may make sense for the commission to say, well, look, an overt hostile act by a country short of war is a similar activity to that. Gaming is broad. I mean, that's the fact of the matter. I mean, but it's broad enough, no matter what, to capture contests of others. Again, it makes more sense at the gatekeeping stage. The reason that their definition is unworkable is because we submit that Congress couldn't have intended the commission to perform the kind of commercial purpose analysis that they're insisting has to be performed at step 1. And I want to give you an additional bit of context. The court may recall that these contracts were submitted to the commission under something called self-certification. Under self-certification, the exchange can list something almost immediately following business day. It's implausible that Congress could have intended the commission to analyze the commercial use of a particular supposed financial product overnight like that in sort of drive-by fashion if it wanted to address the issue before the contract was listed. So analyzing the economics of the contract has to be done at step 2, and it must be done at step 2. Because the public interest, any public interest analysis is necessarily going to give high importance to the economics of the contract.
But in fact, isn't that really the only thing that the CFTC is particularly expert in? I mean, if the Kalshi's reading is correct, that the enumerated categories refer only to the underlines, and therefore that the residual category, Roman 6, requires the commission to identify categories of underlying that are similarly contrary to the public interest. Then then the CFTC would be making determinations of what kind of real world activities as distinct from what kind of event contracts would be contrary to the public interest. That seems like a very strange role to assign to the commission.
Ex ante it is, and Kalshi has never explained, and neither did the district court for that matter, again, how it is possible to read this sentence to mean that involve requires the relationship between the underlying and the enumerated activity. And it's not possible. And the fact of the matter is, there's no canon of construction that can get you out of that box. Canons of construction always have to lead to a reading of a sentence that is possible. Theirs isn't, and I will hasten to add that we did follow the consistent meaning canon. It is the meaning of involve that they agree is the meaning of involve, the American English meaning that captures a variety of relationships.
But your meaning of involve just ends up with us, like a dog chasing its tail. If involve gaming means that the event contract itself is akin to gaming, then that means that every single event contract falls within the special rule.
No, I disagree with that. Again, the commission did not say that, it did not adopt a definition like that. All that it said was that it was looking at contests of others. And this is important. My friends also rely on the trading in their interpretation of gaming. They admit at least one narrow part of this, that Congress was concerned with including sports betting inside the scope of the statute. Well, the only relationship between an NFL game and gaming is the betting. So they have been chastising us for looking at the trading of the contracts, but they do exactly the same thing. And if Congress had written the statute so that the underlying event has to relate it would not have captured those exact things that my friends are.
I'm not sure I followed that.
Yeah.
Because I think under the district court's reading, gaming involves a game or putting stakes on a game. And so if it involves a game, they're saying, yeah, well, the underlying is the Super Bowl.
Yeah, separate issue, right? That is
I'm
about
sorry.
what is gaming. No. There's a lot mixed in here. Concerning what is gaming, that's their argument. It has to be something that's not called a game. But in terms of what involve means, the Super Bowl is not gaming, which they admit. The district court sort of hinted that it believed that football was gaming, which I don't think, they don't defend that. I don't think that's.
The district court said gaming is playing a game. The Super Bowl is a game. So it falls squarely within the district court and dictionary definition.
Well,
I think respectfully, sir, you started out by saying the district court whiffed. I would caution you to consider your tone.
I apologize, Your Honor. Coming up with a word in the heat of the moment, I pulled up that one, but you're correct. The district court mistook.
So I want to catch your argument that you say Kalshi also relies on the transaction. The Super Bowl is a game, but they acknowledge that betting on the Super Bowl is covered under the special rule. And to do so, you say they have to rely on involving a transaction involving being the event contract, not the underlying. Drive that home for me. I'm not
Right.
quite getting it.
Okay. We're all in agreement that the Super Bowl is not gaming in and of itself. It's game. So if you were going to say that the Super Bowl involves gaming, the only way that's so is because of the wagering on the Super Bowl, which is the same connection as the connection between elections and gaming. It's the betting. So Congress, if it could easily have said, it could easily have written the event-focused interpretation, the event-focused reading by saying an agreement, contract, or transaction based on an event that involves the enumerated activities. But it didn't, and for the reasons we're discussing, it would have failed to capture about the only common ground here that we have is that Congress was trying to cover sports betting.
Mr. Schwartz, I guess I wonder whether it really matters what gaming means in this context, or whether it really just all turns on how we understand involves. Because if involves is limited to the underlying thing, then clearly an election is not a game. And an election is not prohibited by state law. So, and if involves has the broader meaning that the CFTC says that it does, then possibly it does. So like the CFTC, I mean, if it can't show both its meaning of involves and the meaning of gaming, it loses. So it seems the first step is essential.
I agree.
And I'm not sure why, and I'm not sure how the CFTC gets past that first step, because, for some of the reasons that Judge Wilkins mentioned, which is that if this kind of contract is gaming, then every kind of trade, every kind of event contract is a game. I mean, it's sort of the essential nature of what that is.
If we're correct on what the word involved means and that you can consider the purpose of the contract or what the trading entails, the only thing that we've captured here is betting on contests. The fact that we cited a dictionary that includes, courts do this all the time, right? And I think sticking to the text here is particularly important. And I'm thinking of the illegal activity prong.
But your definition of involves is that it amounts to gaming, right? So betting on an election outcome amounts to gaming.
That's one of the definitions.
That's one of the definitions, right?
Right.
I think that's the one that does all the work for the CFTC.
Entails relates to, I'm sorry.
Right, entails relates to, but if that's true, then every event contract on anything, would fit into that category.
No, I don't think that's correct. I mean, we're interpreting 5C here. We're not applying the dictionary or any particular state statute. As far as the order goes, is that betting on contests is gaming. So I disagree with that. And I think it's particularly important to stick to the text here. I mean, the canon of construction that I think is significantly more important than the consistent meaning canon, which doesn't get them anywhere, is the canon that when a court interprets a statute, that if before a court interprets a statute that's going to significantly encroach on traditional state police powers, and here we're talking about the authority to regulate their own elections and to protect them, the court has to be absolutely certain. But what Kalshi is asking for here is to actually edit the text to get them there, because there is no textual basis for their interpretation.
Well, they're coming up with a reading. If we don't have to decide the meaning of gambling to rule for you, do we? If we
Correct.
Accept your understanding of involves,
Yeah.
and we accept that event contracts based on elections are contrary to state law, then that allows the commission to do a public interest review.
Correct.
Now, it seems to me the big stumbling block there for you is the bucket shop laws. And I noticed that, and there's express preemption in the statute. It's a little unclear to me what the scope of that is. Kalshi said, I think in a comment, that it thought that the bucket shop laws were preempted by the express preemption in 7 USC 16E2B. Is that your view? And if so, then it seems like helpful for you.
The bucket shop laws, to the extent that they would apply to on-exchange trading, are preempted. So transactions that involve on-exchange trading.
So there's two different preemption arguments. There's an express preemption argument, and I guess there's a conflict preemption argument. And I'm trying to focus on the express preemption argument, which I thought Kalshi itself made in its comment. And I understand the argument also in the briefing that once something is on an exchange, that preempts contrary state law with respect to those products. But putting that aside for a moment, I'm interested in a more express preemption and whether the commission has a position on that.
I don't think the commission has said that, and if they make the argument for me, I appreciate that. But I don't think the commission has said that these sorts of, they're really gambling laws that apply to betting on any contingency. And they're sort of mistaken about how the analysis works procedurally as between an adjudication and a rulemaking.
I find your argument that this is just an adjudication, so we don't have to account for the implications of the statutory interpretation that we're relying on, deeply unsatisfactory. I mean, there may be provisions that don't have to be decided in this case, like what exactly is the scope of exemption of category 6, or if we didn't rely on gambling, what exactly is the scope of that? But when you're relying on a term and the construction that you give it is problematic, I do think that's something that you have to take on board. But so I have another question about the bucket shop laws. Your best argument with respect to that. So one thing strikes me is nobody contends that Congress in the special rule meant to subject all event contracts to public interest review. Nobody thinks that.
Not as a permanent all circumstances matter, but I think an exchange would have, so say tomorrow the states repeal these laws, then they don't have any illegal activity problem. But you're at a point in time, and we were in
They repealed the
2023.
bucket shop. I mean, they have been repealing them because they're really an artifact of a different time when the entire project of event contracts was seen to be questionable. But given that there are bucket shop laws, and given that Congress was focusing on activity under state law, I guess the question is, does the structure, this is a helpful question for you.
Yes, thank you.
Does the structure of and the scope and the whole project of this special rule indicate, no, we're not asking the CFTC or authorizing the CFTC to do a public interest review on everything that has a structure of an event contract. We are trying here to make sure that the CFTC is acting carefully where it trenches on issues that states have legislated in areas of their traditional concern, elections and gambling. I mean, these are states, a lot of states have laws on these matters. So isn't that one way to read the contrary to state law is no, bucket shop laws are just not covered because they're contrary to the whole structure of the thing as focusing on subsets of event contracts. Put that out of the way, and it seems like you're home free.
Yeah, I agree with that as well. I think the point is made in the briefs, perhaps not as clearly as we could have, that is probably not the concern that Congress had here.
And you don't have a position on whether the express preemption provision preempts the bucket shop laws.
I don't believe that it does. I think as written, it applies to on-exchange transactions. I see that I'm,
So
yes.
if we accept your definition of gaming as betting on a contest of others, so I think there's some discussion in the briefs about whether that means it's limited for the purpose of entertainment or not. You would say that it doesn't matter whether it's for the purpose of entertainment or not, so that it could include a contest of others, i.e. elections, even though elections aren't for our entertainment?
Correct. This is where I was going to get into their line drawing problem. If we agree that betting on sporting events is covered, why not betting on the ESPN ESPY Awards? And if that, why not the Grammys? Or Times Person of the Year, or who wins a debate, or the popular vote versus the Electoral College, or most pertinent here, the House national popular vote versus control of the chamber. And if Kalshi believes that House national popular vote, for example, does have a serious commercial purpose, they can come in and make that argument. But our position is that it can't be that Congress intended us to make that judgment essentially overnight. At step one.
Why isn't the line drawing that Congress meant betting on contests of others in the context of games and those sorts of contests, and that would cover things like boxing, football, basketball, et cetera, but not elections?
We're going off the plain meaning of contest here, which, we've cited a definition where entertainment isn't until the third or fourth. Generally, contest means a struggle for some sort of end. And
the Oscars or Billboard charts, those are competitions, contests.
I would say so. My friends are going to stand up and say that we have all kinds of contracts like that, and the CFTC never did anything about it. But that is, of course, not an indication that we've ratified anything like that. But yes, I would. Absolutely, there's a strong argument that those are contests too.
Isn't a war a contest?
Well, I think if you have an express provision for war, then that is where that sort of contract belongs. And there's overlap here, right? I mean, if you look at illegal activity, assassination and terrorism are illegal activity, but there's overlap there. So even to the extent a war could be characterized as a contest, I don't think that is dispositive of what gaming means. I see that I'm well out of time.
Give you some time for rebuttal.
Thank you.
Morning, Mr. Roth.
Good morning. May it please the court. Jakob Roth on behalf of Kalshi. Your Honors, Judge Cobb got this right. The Commission's interpretations of the statute are untenable and lack any meaningful limiting principle. I certainly understand the policy arguments, both for and against election prediction markets, but the question here is, did Congress empower the Commission to prohibit them?
What are the policy arguments that you understand on both sides?
Well, the policy arguments aren't actually presented in the appeal.
No, I appreciate that. I'm just interested in your view because it relates to what you think Congress realistically was up to.
Well, what I think, I'm happy to answer. I mean, what I think Congress was up to, we have to look at the categories of activities that it carved out and said, these are the types of contracts we want the Commission to be able to review. And that's the meat of this appeal, so we'll get to it. But the policy arguments in favor of election prediction markets are twofold. One, they serve legitimate hedging and economic needs. And two, they advance informational value for the public. But again, that goes really to
whether Nate Silver is right about his prediction on an election serves what kind of hedging or information forcing values?
Well, Your Honor, that's not the contract that's at issue in this case. And so that's not the contract where we have any record developed on the economics of it or the purpose of it.
So that's not what you're talking about.
No, not here, because that's not what this case is about. And if they want to try to draw a line between that contract and the ones here, they can try to do that. They haven't. The contracts here are about congressional control, and there's a large appendix that talks about the hedging purposes of that contract and the informational value of that contract. But again, the only issue that's actually presented here is, are these contracts within the narrow enumerated categories of contracts that Congress empowered the agency to look at? And I'd like to go through those, the two that the Commission relies on, and try to explain why their interpretations are not
Mr.
tenable.
Roth, can we first talk about the word involve? So I find the consistent usage argument to be a bit weak in this context, because the word involve sort of by its very nature changes its meaning based on the object that is involved. And so, and I think the Clark case from the Supreme Court that talks about this in a similar context is distinguishable, because I think the categories here are really quite different categories. There's some things that are very specific, like assassination, and there's something like gaming, which is arguably not, it's not, there's a lot of disagreement about what gaming includes. Probably not a lot of disagreement about what assassination includes. So what is your best argument for your reading of involve that doesn't involve the consistent usage canon?
So I think,
Which
Your
I think
Honor,
is, a nice label, but not.
yeah, fair enough. And I understand the point. I think it's actually more helpful to talk about the categories in conjunction with involve, because actually for gaming, and as this came up in the first half, for gaming, I'm actually not sure that involve does a lot of work, because as the district court explained, gaming under the at least one dictionary definition means playing games or putting stakes on games. And so it kind of captures both the underlying
But
game and the
nobody
activity.
questions whether an election is a game. An election is not,
That's our point.
right.
That's our point, that there has to be, under that definition of gaming, putting aside involve, under that definition of gaming, which is the dictionary, the sort of standard dictionary definition, playing games or playing games for stakes. Under that definition of gaming, these contracts are clearly not covered
But that
regardless.
turns on involves, because if the CFTC is correct that in a contract that involves gaming amounts to gaming because it's like betting on the election, then the work that's being done is
No, I don't think so, Your Honor, because there's still no game. So our point is for gaming, it all rises and falls with gaming, because our point is,
Because I think the argument of the CFTC is that the gaming is, they disclaim the notion that the election itself is the game. The gaming is trading an event contract, that's the transaction,
So it all goes back
that
to.
amounts to
involves.
gaming because it's betting on an election.
right, and so they are interpreting gaming to mean gambling, and gambling to be broader than games. That's how they get to
Well,
to
yes,
this.
gambling.
And our point is that can't be right, because if you take there are two definitions of gaming in dictionaries and other sources. The narrower one, which has a game focused and needs to be a game, and then the broader one, which is just betting, gambling. The problem with the broader one is if that's your interpretation, it covers everything by definition.
So here's, I totally understand that argument. And I think that is, that the CFTC has really struggled with this.
Yeah.
But, and even if, which I don't, you don't accept the Lincoln-Feinstein colloquy as in any way binding or, it's post-enactment. But even without looking at that, it seems to me quite commonsensical that the Congress was thinking, we have event contracts, we have an exchange, which is a regulated exchange that is about certain kinds of commercial activity that have proved to be beneficial to commercial life. And then we have other kinds of event contracts that are really frivolous, that are recreational. Who's gonna, be on Time cover Person of the Year, or who's gonna win the Oscars in the soundtrack category? Who is, which of these, famous celebrities in Divorce First? I mean, these are event contracts that are really different from others and not a bright line, I grant you that. But where Congress is thinking, we don't want this exchange, which has its own competencies that relate to markets and finance and hedging and, price-based, information, to become a casino.
Right.
So we're going to say gaming is something that they, transactions that amount to gaming are off the table. So I get it that there's a really tough textual problem, but it seems to me most plausible that that's what Congress was about.
So, Your Honor, what I would say to that is, I understand exactly where Your Honor thinks the line might be for gaming versus not gaming, or at least you've articulated a principle to try to distinguish gaming contracts from all other event contracts. The problem is that is not their argument. That has never been their argument. And he stood up here today and affirmatively disclaimed that argument and said, we can't make any determinations about commercial use or purpose at step one. That's all the public interest inquiry at step two. And they have said that consistently from the order to the district court to their argument on their opening brief on appeal. So if the test for gaming is, does it have, if Your Honor is suggesting that the test for gaming might ask, what is the economic purpose? They have abandoned that like 3 times over and affirmatively said it's not their position. I think the reason for that is that, as we explained in the briefs, it's actually a hard way to do it, because every event contract, even the most economically significant event contract, can be traded for speculation and is often traded for speculation.
The liquidity in the market is provided in part
Exactly.
by people who are sort of
dilly-dallying
and don't know what they're doing. And
So then in order to make it work, you need to ask a question like, well, how often, what is sort of the balance,
and that's
predominant?
what that colloquy says is anything that's sort of predominantly for recreational gambling. And so that's so I get it that the CFTC has disclaimed making a public interest determination in interpreting the statute, but really that's the whole project. What is the subcategory of event contracts that raise, that sort of in the neighborhood of which there may be public interest concerns, and that therefore it's worth doing public interest review of?
So, Your Honor.
So there is a kind of rough draft sense that precisely what the special rule is identifying categories that maybe a lot of the activity is perfectly constructive, but, like things that state laws, render illegal, CFTC is not going to be driven by all of that, but it wants to give a public interest look-see to what underlies that. Are they out-of-date bucket shop laws that nobody's bothered to take off the books? Or are they raising real concerns about the standing of elections in their citizens' minds?
Right. So, Your Honor, this idea of predominant use is the predominant use for hedging versus speculation. That was their test for public interest It was their public interest inquiry before the year 2000 when Congress amended the law. So previously, they always had to analyze public interest at the front end. And what they would ask is the predominant purpose economic or non-economic? Congress repealed that. If we now read gaming to mean the same thing, we're just going back to the pre-2000 regime because it means at the front end for every contract, they're going to say, what's the predominant purpose of this? Is it economic or non-economic? And if it's economic, then we can review it for public interest, at which point we're going to ask the exact same question again. I think that's the reason they have never made this argument, and I don't think it's a basis to uphold or to reverse the district court in light of that.
But I'm saying that it explains, it's part of the understanding of what's in or out, and that that part of why perhaps sloppily Congress put gaming in there is because really front and center for the Congress. I mean, there aren't really that many contracts on assassination or.
Well, there are overseas, I think. But,
right, but on a U.S. market.
Thankfully.
And so in a way, they're really trying to, perhaps artlessly, they're saying, look, we're going to give CFTC the power to look and pick out things that it thinks pose that kind of risk.
Your Honor, I
and
think
look
there's.
At them and you can make your case and you may win your case.
Your Honor, I think there's something to that, but the way I would understand it from the statute is that the way Congress did that was by capturing out this category, gaming, in our view, something relating to playing games, and said, well, that category, that's highly unlikely to have real economic significance.
Why wouldn't 5 then be sports or casino games? Why wouldn't they just said that rather than gaming?
I don't know, Your Honor, but games generally, I mean, made a comment about our definition of games. It's the dictionary definition of games is something you do for amusement, entertainment, diversion. So it captures all of this. And
Congress often uses gaming in a broader sense to mean gambling. I mean, it's sort of a, they don't.
I'm not sure that's true. I mean, the Indian Gaming Regulatory Act is the statute that uses the term gaming, and it refers to casino games, to blackjack, to slot machines, and to horse and dog racing. I mean, that is kind of what we're talking about. Those are games. Those are things you do for amusement.
I mean, don't a lot of Indian casinos have sports betting?
And we agree with that too, because sports are games. Football game is a game.
Gaming commissions. I mean, gaming commissions are gambling regulatory commissions. Right. So gaming, I mean, I do think there's a very strong case that gaming does mean gambling. And then the commission runs into this problem that, at least in your mind, everything that your clients do in the event contract space is gambling. And I think understandably, CFTC says, no.
Right.
And I think understandably, Congress may have been thinking, no, there are event contracts and then there's gambling.
Right. And I agree with all that. And they don't push the broad definition. I mean, they don't really push the broad definition of gaming, i.e. gambling, i.e. all wagering, because they know it's completely untenable. The problem is there's no in-between that for which they can provide any legal source that actually works. The narrower definition, which is found in every dictionary, is what the district court adopted, and we're not covered by that. The broader definition, they agree, is untenable. So they settle on this. Well, I mean, they do two things. First, they say, we don't need to draw a line because this is an adjudication. That's completely wrong. It's a statutory interpretation. They need to give a definition in order to justify their conclusion that these are gaming contracts. And then they say, well, contests is in. We don't have to decide anything else. But that doesn't come from anywhere. There is no dictionary definition of gaming that says contests. They either say games or they say everything. They are just pulling it out to get to the result they want here. And it's not even a test with any policy sense. It doesn't track Your Honor's insight into the economic purpose, because there are lots of contests that have great economic significance. And there's a ton of stuff that has zero economic significance that is not a contest.
But you're requiring a little bit, you're really putting the court that cart before the horse by saying that they have to know, in effect, at the threshold, that everything that's in one of the categories, one of the enumerated categories, is in all circumstances going to be something that having an event contract with respect to is contrary to the public interest. And I think they're saying, you know, gambling, they clearly meant gambling. Gambling in its broadest sense would cover every event contract.
Right.
We're not there. We don't want to be there. We don't have the resources to be there. It would be pointless to be there because a lot of event contracts will just come in and show us the public interest case and will be great, list. On the other hand, they're saying, assuming that as a formal matter of definition, that gaming does mean gambling, then the heartland of it, they say, is gaming in contests of others.
And Your Honor, they're pulling the contest. When the word contests that they're pulling is coming from some state gambling statutes where in context, it could not be any clearer. They are not talking about elections, just like they are not talking about corporate board contests, and they're not talking about market share contests. They're not talking about lawsuits, things that can be colloquially described as contests. That is not what those statutes are talking about. They refer to things like contests of chance or speed, skill, and endurance of human or beast. I mean, when you read these things in context, it is abundantly clear elections are not what they are talking about. The district court recognized this too in the context of the federal statute that they cite, which talks about sports, contests of chance, or games of chance and contests. You look at those three things together, they're not talking about elections. And that's where they're getting the word contest, because it's not coming from any definition in a dictionary.
On sports, betting on games of chance, betting on contests, I'm not sure if that were what the statute said, I think they'd be in pretty good shape on betting on contests. But so putting aside, you don't have, if you win on gaming, you still have to win on unlawful interstate law.
I'm happy to switch to
And the unlawful interstate law, like it seems to me your whole argument is about the bucket shop laws. Am I wrong?
Is about, excuse me?
The bucket shop laws.
That is a big part of the argument.
A big part of the argument.
Yes, because you want me to flesh that out a little bit? I mean, they say when the statute asks, does the contract involve unlawful activity? That means does trading the contract off an exchange, would that violate state law? And under the bucket shop statutes, every event contract, if it's traded off an exchange, would violate some state law. Not every state has these, but lots of them do. And so our point is, that's what tells us that they are focused on the wrong thing. In order to make this really work in context, the inquiry needs to be, is the subject matter of the contract related to unlawful activity? Just like the analysis is, does the subject matter of the contract relate to war? Does the subject matter of the contract relate to terrorism? Does the subject matter of the contract relate to assassination? If you read those four things together, that's what the statute is trying to get at. It's looking at the underlying event and asking, is there a relationship between the underlying event and the enumerated activity? Because we don't want people profiting from war. We don't want people profiting from terrorism, and we don't want people profiting from crime. So it makes perfect sense when you read it that way and you don't walk into this problem of swallowing the rule, swallowing all the other exceptions and rendering this stuff superfluous. Your Honor asked about—
To me, I think the problem for you with that argument is if I just look at this statute kind of at the 10,000 foot level, and I see, well, there's 6 different categories. There's a catch-all, other similar activity, but the first 5, they all seem to be, as you just said, kind of things that Congress would have thought that just as a matter of public policy, we don't think that people should be kind of trading and profiting off of whether someone is going to commit a crime or not.
Right.
Whether an act of terror is going to occur, an assassination or a war. I think then that supports kind of the CFTC's view that gaming means gambling, because that is something that states and Congress have traditionally wanted to regulate and minimize, and might want to regulate here. And, gambling is one of the very common, and in some dictionaries, it's the first definition of gaming.
Right.
And so I take your point that gambling is broad, and then that might swallow up the whole statute, but if you're just kind of looking at this as what was Congress's purpose, it would seem that what Congress's purpose was more likely that they were concerned about gambling than whether, who's going to win the Super Bowl just as a game.
Well, Your Honor, the legislative history is exclusively about sports when it talks about gaming. So I think there is a reason to believe Congress was particularly concerned at the time it enacted this statute that about sports betting, and that was probably what they were getting at with the word gaming. Certainly, Congress was aware that state laws had these bucket shop statutes that, if taken on their face, would prohibit all sorts of derivatives contracts and futures markets. And that's been true for a very long time, decades. I mean, Justice Holmes talked about this in that case that we cite, the opinion. So I think in the brief. So I think it's pretty clear Congress was not trying to cover the waterfront, because we have these markets. They're supposed to cover something. And if you read gambling in its broadest possible sense, or if you read involve unlawful activity in the way the commission wants to read it, you do swallow up everything. And I think that's what really the district court was driven by in recognizing this just can't be right. You know, Your Honor asked about the express preemption that mentions the bucket shop laws. So it's not in any of the briefing, because we looked at it and concluded it doesn't apply, but it is sort of confusing. So my understanding of that provision is that it deals with transactions that are not on a regulated exchange, but that are carved out by other parts of the statute. So it talks about excluded from the act. So that's why nobody talks about it.
Permitted unregulated?
In other words, there are certain situations where the commission can authorize off-exchange stuff to happen, even though generally speaking, the rule is if you're going to trade these, it has to be on a regulated exchange. The commission is allowed to sort of carve certain things out from that. And if it carves it out, then this express preemption provision says the state law doesn't apply. But that's not the preemption rule that we relied on, that the commission relied on, that anyone discussed in the order or the briefs below or on appeal.
That preempts bucket shop laws. What you're saying now is that more precisely, that preempts bucket shop laws as applied to this activity that might be subject to a carve out that the CFTC is effectively blessing.
Right. Okay. And that's why it's not really relevant.
It seems like there's a sort of a structural preemption argument also, and I'd be interested in your thoughts on it. The very notion, so the bucket shop law is problematic, as you say, because some states still have them. And if we read involve to say that trading on things that if a state law outlaws certain trading, then similar trading is what the contrary to state law refers to. That's going to give the commission the ability to review every event contract.
Right.
But nobody thinks that this, and I know this sort of cuts both ways. Your argument is, and nobody thinks that.
Yes, exactly.
Therefore, you can't read this language as involve points to trades of event contracts that amount to activity unlawful under state law. It has to be trades of event contracts, the underlying of which is activity unlawful under state law. That's
or relates to, yes.
That's your view. But I guess once you put the bucket shop laws off the table, which I think the very structure of this statute effectively does, then it seems to me it's open to say, actually what Congress is worried about is states' regulation of things like betting on elections and gambling. And so if the state has done the work of narrowing down what kinds of gambling it thinks is unlawful, what kinds of,
Yeah, I understand the question. I just don't understand how we can take it off the table consistent with the text of the statute other than through our interpretation.
Well, but interpretation involves looking at words and dictionaries and meaning.
Right.
And also
context.
really uncontroversially, looking at the structure of the statute. And
Yeah.
the statute lists a bunch of things that are, none of which would be necessary if the first one gave CFTC authority to do everything that could conceivably be in the rest.
Right. So we offer an interpretation of the statute that avoids that problem.
Only because you read and the first
Through
one,
involve,
I mean,
yeah.
I understand gambling has a similar,
Yeah.
or gaming has a similar problem, but the first category
Yeah.
only has that problem because of the bucket.
Yeah, I agree. But the problem is, look, if Congress wanted to say any unlawful activity, any activity unlawful under state law, but for the bucket shop laws, then I would understand the point. And Congress did refer to the bucket shop laws elsewhere in the act. So it's not like they didn't know that these laws are out there. They didn't say that. They said any state law. And again, I think the natural reading of that again aligns it with the terrorism, war, and assassination
Is that it's the underlying.
is that it relates to the
So I think you have a problem with your underlying, with looking at all these enumerated categories as exclusively dealing with the underlying. If you look at enumerated category 6, right? So category 6 gives the commission residual power to define additional categories of activity subject to public interest review.
right.
Your client reads category 6 I mean, this is bizarre, right? As assigning to this commission the threshold decision of which activities in the world, not which activities on the market they regulate, but which activities in the world are contrary to the public interest. That can't be right.
Let me say a couple things about that, because I had a feeling Your Honor might ask this question. So first of all, I'll just say 6 is not an issue, and we actually haven't taken a position on 6.
Just as we push them on,
I
your reading has to make sense.
I agree, but what I would say is whatever we think about 6, the point about 1 holds. So I don't want to lose sight of that. Like, even if we think, oh, 6 is just, it's different from the others because it's this residual thing and they're getting at something else, that doesn't really take away from our point that with respect to the unlawful activity, it's got to be referring to the underlying. But let me go to the merits of it. I was thinking, like, what is an example of something Congress could say is similar in that it is contrary to the public interest and a lot, right, in a way that is similar to war, terrorism, assassination. So one example I came up with is natural disasters. So I think the commission could say, look, natural disasters are similar to war and assassination and terrorism, and they're contrary to the public interest. And you know what? We don't want people trading contracts on whether the wildfires in LA are going to consume a certain number of acres by a certain date. That would be bad. That would be bad in the same way that trading on unlawful activity is bad and trading on war is bad. We don't want people to profit from it. And we don't want to give people incentives to go commit arson.
It's like a strange example, given that so much of commodities trading generally was designed to hedge against natural disasters. And everything on this list is a human
Yeah, I think,
agency.
yeah. And so
that
maybe
seems
somebody
like a
could challenge it,
That
but
seems like a strange example.
I do think that when you're dealing with at least a disaster that can be affected by human behavior in a way like a fire, there would be a better argument for them to say, we don't want this, we think it's similar. It's just an example. I mean, look, they've never used this authority, so we're all sort of guessing about what it means, what its scope is, how they can use it. I don't think it's unusual to say, look, that they want things that are similar to these other listed activities. The other listed activities are things that are, at least some of them, things that are bad, right? We don't like terrorism, we don't like war, we don't want people trading on it. And so the commission can say, look, there are other things like that that are similar. The problem with Your Honor, can I just make one more point about this? The other problem, I think, with what Your Honor is suggesting about 6 is it would have the commission make the same inquiry twice. Because you get added to 6, if you get added to 6, you then get subjected to public interest review. So if the question under 6 looks at the trading of the contract rather than the underlying, then what we would be saying is, well, the commission can pass a regulation that says, trading a contract of this sort is contrary to the public interest. And if it does that, it gets to review those contracts to decide if trading them would violate the public interest. So it actually duplicates the step 1 and step 2.
You can see it as a category. So just like, it sort of makes a virtue of the fact that this is a threshold for a public interest review. So you can say, well, the category of, trading on things that are contrary to state law is subject to public interest review, but it may be that there are certain things that are contrary to state law where we really want the information forcing to, and so the commission might look at that and say, yeah, we had review, but we say, go ahead and offer
Yeah.
that. So it is a different inquiry, and it just
Yeah.
makes much more sense to say that Category 6 empowers the commission to determine whether trading on certain events is contrary to the public interest, or really, and I think you have pointed to something that's a little clumsy, just one thing that's a little clumsy about the way this statute is written, which is it really should say to consider whether trading on certain events is likely to be or raises an atypical risk of being contrary to the public interest,
Right.
such that public interest review of individual such contracts is warranted. But when you look at this as whether it is better read as referring to CFTC making determinations about underlyings or CFTC making determinations about whether it's contrary to the public interest or might well be contrary to the public interest to trade on certain events, to me, the latter is much more powerful. And if you agree, then I think you're back in hot water on involves.
Well, I think what I would say is, I'm not sure I agree that that is the better reading. To me, the better reading is 1 through 6 is looking at the underlying, and then if you
1 through
pass,
5. Oh,
1 through 6 looks at the underlying, and if you get past that, then the public interest inquiry looks at the trading. So it's 2 different levels. But I would also say, look, 6 is a bit of a, I think for reasons that have come out in the discussion, 6 is a bit of a poor fit with the others. But again, I don't think that really detracts from the point that 1, 2, 3, and 4 clearly go together in a way that makes sense and is aligned and doesn't walk into the overbreadth swallowing the rule problem. So I still think that's the better reading of 1 through 4, and that's enough for purposes of this case. The issues with 6 are really not presented.
Mr. Roth, I wanted to just understand something about the logic of your argument. So it seems to me for the CFTC to have the authority to do this, they need to prevail across the board, both on involves and on whether this involves gaming or something prohibited by state law. They need to show both. It seems to me to disprove their authority, you need to prevail, Kalshi needs to prevail on only one of those things because commission needs both. But when I asked you a question about this earlier, you suggested that it really, your interpretation relies on both parts. So for Kalshi to win, do you need to show both that your meaning of involves and your meaning of gaming or prohibited by state law is the correct one?
There's different
Because
ways
it
it can
seems that
shake
maybe
out.
you've conceded that you need to show more than I thought was necessary.
I just think the easiest argument on gaming is that there needs to be a game, and that doesn't get you into the whole issue. I think
Right, so that's just one problem.
Yeah, I think you're right. Your Honor is correct. Involve would cut across and is enough to win across the
That's
board.
sufficient.
It's sufficient, but I think the involve argument, it's tied much more closely to the unlawful activity prong than the gaming prong, because gaming by its nature sort of can capture both levels. It's just not as it doesn't seem to fit. The argument doesn't do as much on gaming. I just think the easier argument on gaming is the definition of gaming and the overbreadth of gambling as an alternative, and the inability of the commission to draw a line that is rooted in any legal authority to that would keep us in while also not covering the waterfront. But involve, I think Your Honor is correct. Involve can
I guess
capture.
I'm not sure I understand why involve doesn't have the same intersection with gaming that it does. Like, why do you think that connection is harder to? I guess I'm not sure I fully understand that argument.
It's just that gaming, as the district court said, can cover both the playing of the game and the betting on the game. So if we've sort of can persuade the court that gaming requires a game, it doesn't really matter. Like, they can say we should look at the whole transaction. It doesn't matter. There's still no game at the bottom, and so we still win on that, and you never really grapple with the involve issue. It just depends on what sequence the court considers the questions. I'm trying to present sort of what I view as the simplest path on the two prongs. Well, Your Honor, if there are no further questions, I'll just conclude by noting, as I said at the outset, I know there are some people who don't think we should have these markets, and actually there has been a bill introduced in Congress that would prohibit them. But as the law currently stands, prohibit event contracts on elections. But as the law currently stands, they are permissible. The commission overreached in subjecting them to public interest review, and we think Judge Cobb's order should therefore be affirmed.
But you do have the courage of your convictions that if it came to public interest review, that you would prohibit.
Oh yeah, and we made that argument robustly in the district court, and it was argued orally at the summary judgment hearing, but the court didn't have to reach it. I don't think this court has to reach it. Well, this court can't really reach it because hasn't been briefed, but no court needs to reach it because we prevailed at step one.
I meant to ask you earlier, I asked your friend on the other side, what, if any, impact excluded commodities and the definition of excluded commodities, does it help inform the definition of either gaming or the definition of involved in your view?
Well, I think it helps us in the sense that the definition of excluded commodity includes the events, right? The occurrences, extent of occurrences or contingencies. And our point is that means by definition, an event contract involves staking money on a contingency. If that's the definition of an event contract, we can't possibly read gaming to mean gambling in its broadest sense, because that would then fully overlap with the definition of event contract, and that would render the other prongs superfluous and also sort of flip the statutory structure on its head.
Can you say that again? You said the excluded commodities refers to the event?
So excluded commodity is defined to include the occurrence, extent of occurrence. I don't have the exact statutory phrase, but an occurrence. That is what the Act defines as the excluded commodity, which is a type of commodity. And so a contract on an occurrence is subject, that's why we're subject to this whole regime in the first place. It's got to be a contingent, it's got to be an event not within the control of the party. So it's a contingent event. And if it's a contingent event, wagering on a contingent event is, again, under the broadest definition of gambling, that is gambling. So that can't be what Congress is getting at with the special rule, because that would sort of flip everything upside down.
Yeah, feel like a dog chasing its tail, trying to figure out this statute. Because excluded commodity talks about, as you said, an occurrence, the extent of an occurrence or contingency.
Right.
Beyond the control of the party.
Right.
So one way that I could gamble would be, I could go to, local casino and play blackjack.
Mm-hmm.
And so I am actively, playing, and my skill at the game is going to impact whether I win money or lose money. But that's not something that is outside the control of the parties to the gambling transaction, because I have some control and I'm a party to that transaction, right? But if I go to the casino and place a bet on a playoff game, that event is outside of my control. So there's different ways that one can gamble. One might be seen as inside my control, outside my control. what does that do? Does that undermine a definition of gaming as gambling, or does it support it, or not?
Your Honor, I'm not sure I have any insights into that. Nobody's really discussed the control of the parties element of the definition in this litigation from the beginning. And so how that kind of plays into it, I'm not sure. I haven't thought it through. I don't think the commission thought it through. It certainly wasn't related to the district court's analysis or, for present purposes, the commission's arguments about why the district court erred. So I'm not sure of the answer, but I don't think the court necessarily has to get into that to understand.
Well, I thought that we might, because the whole definition in the special rule starts out that it's in connection with agreements, contracts, transactions, or swaps in excluding commodities. So
Right.
all of the things in Roman 1 through 6 are necessarily excluded commodities.
Right. That's correct.
And so if there's a definition of gaming
Yeah.
that does not comport with outside the control of the parties.
I see what you're understanding. I see what you're saying.
Transaction, then that definition can't be right.
Right. So I think what you're saying is if one was himself involved in a say a poker game, okay, then that might not be outside his control, and therefore a contract on that event would not be subject to this rule in the first place because it wouldn't be an excluded commodity. That might be right, but that just kind of takes that whole category of situations where you are yourself involved and have some control over it out of the analysis, and I don't know that changes anything about the big picture arguments parties are making. Sorry if that's unsatisfying.
Right,
Thank you, Your Honors.
thank you. And we'll hear from Mr. Schwartz.
Right. I think it's pretty clear at this point that other than our disagreement about what the word gaming means, they have no textual argument about the rest of the statute. It is about whether it would, quote, align better, or if it would suit their policy purposes better if it read the way they said. So I think the court doesn't need to proceed any further on meaning of the word involve and its close connection to at least the illegal activity.
What do you mean we don't need to proceed any further?
Well, on what the word involved means, they have no textual argument about that. I think the plain meaning
Well, we
of
need to
involved.
decide it, right?
Right, and we lay out the textual argument about that. We agree that it means to relate to entail, to have as a necessary feature or consequence. They agree with that. We agree it covers a variety of relationships and it has its ordinary meaning in Section 5C. So thinking about whether it would align better if Congress had chosen some other words, I don't think the court needs to get there or ought to get there. I am a little puzzled about two things that my friend, Mr. Roth, said. He started out, as they do, by saying the commission announced a rule that all gambling is gaming within the meaning of 5C. I mean, that's their argument. It's not what we said.
I don't take them to be saying that. I take them to be saying that the implications of your initial position in the order that gaming included, the gaming meant gambling, which frankly, I think you're right, that gaming means gambling. That the problem with that is that it swallows the whole decision in 2000 to no longer have sort of general public interest review. And so it's contrary to the project of this statute, which has these enumerated.
Right, yeah. So I think if the commission had said dictionary definition of gaming is gambling, therefore these event contracts involve gaming, that would be a problem. But what the commission did, there's a list of the sources of the interpretation of gaming. I think it's pages 8 and 9 of the order. And it starts with the dictionary. It talks about state statutes that include betting on contests of others in their gambling definition. By the way, New Mexico, their statute says that betting on elections is gaming. So that is, I think, a pretty clear connection that at least supports the reasonableness of what the commission did here. And we looked to state statutes because states are the almost exclusive regulators of gaming. So it was perfectly appropriate to do that. The only implications of the order are that if somebody comes to the commission with a contract on a contest, then the commission will either have to follow what it said here, that betting on contests of others is gaming, or it will have to announce a change and explain why. If somebody comes with a contract that does not involve, and there's a footnote that says this, if there were a contract presented that did not involve betting on a contest of others, that would be different. So, I mean, it's a bit like the common law process in courts, and SEC versus Chenery, or Chenery 2 as it's called, talks about this, right? You got a new.
What does the of others do for you? Is that just to distinguish it from their playing a game or playing a game for stakes because it's your own contest that you're betting on when you're playing for stakes? It just seems like it feels more gerrymandered when you say a contest of others as opposed to just a contest.
Right now, I think it's as Mr. Roth said, that if he and I, to give another example, he and I decide to play basketball for $50, that's not what we're talking about here. And the state statutes use the word contest of others, I think for precisely that reason. They don't mean to sweep into the anti-gambling laws, something that Mr. Roth might bet me on in terms of feats of strength or something like that. And in terms of what the word contest means, I think I heard him to say that contests other than sporting events are not within the scope of state gambling laws, which I find remarkable. I think the gaming commissions would be surprised to hear that. The Washington State Gambling Commission has put out a statement expressing near outrage, I think, of the fact that what was illegal betting on elections is now available across the United States there. I don't think it's tenable to say that, well, if what you're offering is a bet on the presidential election, that's not covered by state law. Go ahead.
And indeed, I mean, the numbers for many years, that was really kind of the primary anti-gambling, enforcement of local officials, used to call it policy, but that's a contest or that's a betting that doesn't involve sports, but that's always been illegal and regulated by states, right?
Right. And if you want to list a new bet, you offer a new bet at your casino, typically you have to go to the State Gaming Commission and get their approval to put it on there. I don't think it's accurate to say that these types of bets, because they're not on games, are outside the jurisdiction of the state regulators. And again, we're not applying state statutes as a whole. We're just looking to them for some guidance on what gaming means because it's their business typically.
Are you making a preemption argument? Are you making an argument that the special rule preempts bucket shop laws, but not state laws that prevent betting on elections?
No, I don't think we are. I don't think we are making that argument. I think the argument we're making about the bucket shop laws is, number one, the statute elsewhere deals with bucket shop laws. I think Your Honor commented that seems to be the kind of whole overriding, and it is the motivating force of futures regulation, right? So
it doesn't deal with them by the term bucket shop laws or expressly, but just structurally, you're saying.
Right. Yes. I mean, the reason that Congress preempted the application of state law regarding on exchange trading is because there was a national interest in hedging and price discovery, which we contend is not served by these contracts, but as Mr. Roth said, is a question for another day. They wanted to have this act. It's important to have derivatives where you can hedge against risks and where prices can be formed and disseminated. So I think that is, the bucket shop laws are structurally tied up in the rest of the statute. That's number one. But number two is that the commission did not have occasion to and should not take it on its own initiative to examine hypothetical contracts about an uncertain time in the future with an unknown legal landscape about what might be legal or illegal under state law. So even if we were talking about state laws here, there is no way for the commission to know what at some future date will be outlawed by the states. The way this would come up is somebody,
But the commission has argued that the reasoning of this adjudication would apply in a future case.
if you can.
You've said that in this argument.
Right, yes, it would. It would. But if the facts are different in the future, then that would be the distinction between this case and others. So I think what
Your
we've said
agencies
can't
really
be.
try to have it both ways. You can announce a new rule in an adjudication, or you can decide, in a future adjudication to discard that rule.
No, I don't
Have
think
it
so.
both
In fact,
ways.
no, I don't think we're trying to, respectfully, I don't think we're trying to have it both ways. I think, in fact, what we did here is very, very narrow. We decided the case on the facts before us, and it is only the facts before us that, just like a court would serve as precedential for other cases. See here, I will just, if with the court's indulgence, I will see if there was anything else that I wanted to bring up. No, I will just conclude by saying, to the extent that there is a textual argument on one side and no textual argument on the other side, particularly in light of a major intrusion on state election law here, the court should not look at the statute in a way that runs counter to the text and apply it to these cases. I think even if it were ambiguous, the court would have to be absolutely sure. I think when the text cuts against the interpretation that my friends are asking for, I don't think it's defensible to read the statute that way.
Thank you, Mr. Schwartz.
Thank you.
The case is submitted. The court will take a 5-minute break.
Honorable court will now take a brief recess.
I don't need it. If you don't want fun. I was actually going to return to you, not your bike. Did you get my note? Good.
Hi, Suki Hoshijima. Nice to meet you, Gary. I know a few cases together. Yeah, we do. Pretty nice to know today. Yeah. You Oklahoma based? Yeah, I'm from yesterday. I did, yeah. I got a 2 o'clock flight.
Stand, please. This honorable court is again in session. Be seated, please. Case number 24-1009, State of West Virginia et al. Petitioner versus Environmental Protection Agency and Michael S. Reagan, Administrator, United States Environmental Protection Agency. Mr. Mansinghani for the petitioners, Mr. Hoshijima for the respondents, Mr. Griego for the interveners.
Good morning, Mr. Mansinghani. You may begin when you're ready.
Thank you, Your Honor. Mithun Mansinghani on behalf of West Virginia, Oklahoma, and a total of 26 states as petitioners. I'd like to reserve 3 minutes for rebuttal. Under Section 111D, states set the standard of performance for existing sources that reflect EPA's best system of emissions reduction. EPA promulgates regulations governing the procedure for how states submit plans, but that procedure shall permit states to take into account remaining useful life and other source-specific factors in setting a standard of performance for a particular source. The statute thus clearly grants states discretion in setting standards of performance. And the question here is whether, when a state reasonably exercises that discretion, EPA can nonetheless reject those reasonable judgments as EPA purports to do in the challenged rule. The answer is no. Nothing in the statute grants EPA that power. EPA interprets the language shall permit not as a command to honor state discretion, but as a power to restrict it. But nowhere in law do legislative commands that the executive shall permit something without more mean that the executive is free to restrict it in any way it wants. And so too with EPA's creation of a power to error correct approved 111D plans or call for plan revisions, which Congress gave in Section 110K of the Clean Air Act for 110 plans, but did not give in Section 111D for 111 plans. The rule is also arbitrary and capricious because it set a deadline for the submission of state plans that was not justified by the evidence before it. EPA rejected a 9-month deadline because the data showed that most states took longer than 9 months to submit their plans, but the exact same is true of the 18-month deadline that EPA chose. EPA wholly failed to explain why 18 months is adequate based on the record evidence before it, and for all these reasons, we ask the court to vacate the rule. I'm happy to answer questions on either of those topics.
When you say it wholly failed to consider why, if 9 months was too short, 18 months wasn't also too short, it didn't consider only the historical data about how long states took to comply. So it did explain. It explained by looking at statutes that it thought were roughly similar in terms of the activity they required of a state and described how long, and identified that the EPA had given 18 months for analogous inquiries. It looked at the need for prompt control of emissions. There's a whole series of things that it looked at. It looked at information provided by states on the sort of different procedural components. It looked in shifting from 15 months to 18 months at the additional work of, I think it's public engagement, states engaging with the public. And it also, it looked at a comment that said, yeah, there is historical data, but some of the states have taken longer than necessary. And it also looked, for example, at this is only a default. And at that, it means that in two ways. One, when a particular emissions guideline is published, EPA can, and indeed it has, extended more time for states to submit their plans. And even when it turns out for a particular state that it's too short, there's no sanction for going longer. So when you say they didn't at all explain why they didn't just adopt the lowest common denominator of the amount of time that states have historically have taken, what's wrong with the understanding that they did explain? They looked at, this is a timeline, right? It's longer, shorter. And so all the different factors go to the same question. And so they did explain.
So there's a lot there, and I'm going to do my best to try to tackle all of it.
You know it already.
But feel free to interrupt me if I'm going too long. So ultimately, I think with respect to the record evidence, and there's two big pieces of record evidence here, which is the data of how long it took states to submit 111 plans and what states told EPA of how long state procedures take to actually adopt these plans. EPA did not explain at all how their 18-month deadline was consistent with that data. It instead, as you pointed out, Judge Pillard, moved straight to, we're just going to compare to other statutes, and I can get to those other statutes later. But at most, EPA said, offered at most ipsa dixit by saying, well, we considered these things. It didn't actually explain how the data that it collected or the state plan or the state comments on state procedures was consistent with an 18-month deadline. Now, in terms of, well, EPA can always extend the deadline, of course, the fact that they've done so a couple of times already might only indicate that the deadline, the default deadline, is too short. And of course, in American Lung Association, they could have shortened the deadline for a specific emissions guideline, and yet the court did not hesitate in striking down the 36-month deadline as inadequately explained. And then the last thing I'll say on that is that the extension is with respect to a particular emissions guideline, but once that emissions guideline is there, EPA very clearly said at Joint Appendix 47 that it won't offer particular states any extensions to the extent that they need them.
Mr. Mansing, I guess I'm not sure what more EPA is supposed to say. So, I mean, the statute, I mean, it might be that the best reading of the statutory scheme is that it should be a 36-month deadline because that's what's in Section 110. But this court has said that's not a sufficient basis. And so EPA has to explain why, you know, how it balances different interests. But I mean, what if they had picked 24 months or, you know, 38 months, or I'm just, once you're talking about a deadline where you're looking at, wanting states to comply in a timely manner, but also give them enough time. I don't know. This is the sort of thing. I mean, how much is an agency really supposed to say?
Well, certainly the failure to explain is the core holding of American Lung Association. And so if they're making the mirror image error here, it should equally deserve vacature. And as far as what they should do, so for example, they said, look, we saw that states said that their procedures take somewhere between 15 to 36 months. We can't accommodate every state, so the end, right? That doesn't explain how what the state's comments were on state procedures is consistent with their 18-month deadline. What they could have done is what they did with their federal deadline. They said, look, here's every step of the process of doing a federal implementation plan. Here's how long that we think it'll take. And we're setting our federal deadline as long as that, at that level. They could have done the same with respect to what they think state procedures could be. They don't have to accommodate the least common denominator, but what they can't do is just ignore as a whole how long states take to submit the plan. Same with respect to the data. I think them saying that states took longer than they needed is a post hoc rationalization. I don't see it anywhere in the rule, but they at least could have explained why they think states took longer than they needed, rather than collecting the data and then doing nothing with it with respect to setting the 18-month deadline.
Well, you say, how is it consistent with the data. I don't think that's the obligation. They don't have to make their timeline consistent. And you said that this is the mirror image of what happened and what we found inadequate in an American lung, but that's not right, because in American lung, literally, we did not mention the need for speed, the need to, the costs of a longer deadline. And it seems like, in a way, your argument is doing that too. It doesn't need to be consistent with the data, because, as Judge Rao's question mentioned, that the task before EPA is necessarily dealing with conflicting exigencies, right? It needs to control, have a process to control these harmful emissions and do it in a way that is orderly. And it mentioned and collected this data. It's a pretty limited data set. And it does mention it, and it does consider it. It does actually take action in terms of lengthening the default deadline based on it. It's a little bit hard to say what more, without micromanaging the agency, what more we could demand.
Well, so the reason it rejected the 9-month deadline was because most states didn't meet the 9-month dedeadline, but the exact same is true of the 18-month deadline. So that's
Most states
inconsistent
did, though,
reasoning.
meet the
About a quarter.
More
but,
than a quarter, yeah.
But with respect to American Lung Association, I don't think the only aspect of that decision is this failure to consider the environmental protection needs. The court basically, I read it as offering 3 reasons: that it had the burden of justification for timeframes, so it rejected mirroring 110 without reasoned support, and that it failed to document any problems with existing deadlines. And so EPA then responded to that by collecting a bunch of data, rejected a 9-month timeline, but never explained how they were using that data to come up with the 18-month timeline, along, of course, with the state procedures problem. And so the question isn't necessarily that they had to pick the exact average. It's that they had to come to a recent conclusion based on the record evidence before it. So they had the record evidence before it, and I think in this case and in any other case, if that record evidence is not somehow dealt with in a reasoned explanation, that's arbitrary and capricious.
What is your best argument that failure of reasoning that you've alleged is not just harmless error?
Well, I mean,
unless you sort of have to tie it to the median amount of time or the average amount of time or something like that.
So one is, with respect to how long state procedures take, I think that it's certainly not harmless error, because if you took into account state procedures, you'd have to get something higher than 18 months. And even if you're not getting to the average of 45 months, I think what the data does show is that the 110 deadline that Congress set as a reference point, I acknowledge not a strict reference point, but the data does show that 110 deadline is actually somewhat consistent with the data that EPA ended up collecting, unlike was the case in American Lung Association, where there was no data.
Job. I mean, EPA does discuss that.
They do.
Many more different sources, emissions.
I think that 110 plans can be complex in that way, though not always, right? The methane rule has a ton of sources. It's a 111 rule. And 111 rules and 111 plans can be more complex in the sense that they take into consideration remaining useful life and other factors to tailor things, unlike 110 plans where they're just trying to hit that one target of the national ambient air quality standards. With respect to the statutory comparators, we've of course made our arguments as to why they should have at least looked at 110. But the other ones that they chose are sort of picking and choosing. I don't see why they chose those 2. So 129, they admit, is just not comparable because of this lack of source-specific tailoring. And 189, well, that's about non-attainment plans for the NAAQS. And they, for some reason, chose to only compare it to the shortest of those deadlines. This course, Wild Earth Guardians 2016 case talks about particulate matter as being the strictest of the deadlines, but most of the 110 deadlines and the NAAQS deadlines are 36 months. So it just seems like an awful lot of cherry picking there. I do want to talk about remaining useful life before my time expires, although I know that's not necessarily the strictest of limits, but
Question,
yes.
so West Virginia argues that EPA review here should be only for reasonableness,
Mm.
right? But EPA, the statutory standard is that EPA can determine whether the SIPs are satisfactory. And I'm wondering, I mean, satisfactory, why doesn't that encompass more than reasonableness? Like, a plan might be unsatisfactory if it doesn't comply with the underlying statute or, violates a different regulation or standard or something like that. So, but your position seems to be that the review is exclusively for reasonableness.
Not quite, Your Honor. I do believe it is for review of both reasonableness and compliance with the statute. And EPA agrees it's for compliance with the statute at Joint Appendix 68, as well as page 64 of their response brief. That's similar to the review that happens in Section 110. But the way I would frame it is this way with respect to, let's say it does comply with the statute.
Right, so there's no legal infirmity.
Right. The way I'd frame it is nothing in the statute allows EPA to fault state plans as unsatisfactory if a state reasonably takes into consideration factors that Congress expressly permitted them to take into account. So if states shall be permitted to take into account remaining useful life and other factors, and states reasonably do so, I don't think EPA has the statutory authority to declare that unsatisfactory. And with respect to their new restrictions on remaining useful life, understand that these are restrictions on top of the existing reasonableness requirements already in the statute, already in the regulations. So the regulations currently say if states can deviate if there's unreasonable costs. And now these regulations on top of that say it has to be also based on information fundamentally different from what EPA considered. And we think that layering on top of the reasonableness standards is what's facially unlawful.
But I take them to be making sort of the inverse argument, which is, that rule-off shouldn't be a second, double counting the same thing that the EPA already took into account. They, for example, look at all the sources. They said something that they think is achievable for the category. And if every source that sort of was in that group that was below average and therefore was part of the data that made EPA pick the limitation that it did as realistic, and all the ones that are below average say, well, we have other conditions, then you're sort of exempting them from a standard that's been set, already taking those conditions into account. But that seems like double counting to me.
I don't think it's double counting. I think EPA acknowledges that if there is something as an extreme outlier, even if it was accounted for inside their overall industry-wide data, that it would be something that might justify a variance here. And I think the question is, who gets to make that sort of line drawing, right? If a state is relying on something that's insubstantial or de minimis, I think the EPA can say, no, that's not a reasonable deviation. But in the greenhouse gas rule, EPA says, well, it might be something that only was in the 95th percentile of costs. If a state said, no, actually, this is in the 80th percentile of cost, and we think that that's an unreasonable cost, and so we're going to do something slightly different, I don't think that that's something the EPA has the authority to reject. But the other thing I'd say is that the way EPA frames fundamentally different, it says that if the EPA did not consider any information pertaining to a certain circumstance in making its determination, facility-specific information relevant to that circumstance may be fundamentally different. And that's at Joint Appendix 74. But if, for example, EPA, as it should, consider costs in setting the best system of emissions reduction, what that implies is that states can't consider costs in terms of remaining useful life and other factors and setting state-specific, source-specific standards of performance. And I think the third thing they say, and this is at their brief on page 32, is if a source could meet those guidelines, it must comply. And that's just like an impossibility standard, and I think is very far from what the statute allows EPA to do. With remaining useful life, I think the important thing, of course, is that states set standards of performance. EPA does procedural rules, and those procedurals shall permit
Not
state
just.
discretion.
I mean, states set standards of performance, but they have to reflect the emissions standards that are the degree of emission limitation that EPA has calculated in light of the best system of emission reduction. So that is not just procedural. The EPA determines a level of emission limitation that is adequately demonstrated.
I wholly agree with that.
Okay.
States, the standard performance have to reflect what EPA's determination is in the terms of best system of emissions reduction. But in terms of when you can vary for that, that is what's given to states to exercise reasonable discretion in doing so. And I think that this is bolstered by the precedent all over the Clean Air Act of cooperative federalism, where the EPA sets some general standards, states submit plans to reflect that standard, but tailored to local conditions, and EPA reviews on a limited basis and can promulgate a federal plan if disapproved. This is true in the 110 context, and in case after case, like Train and Union Electric, the court has emphasized that states have wide discretion and considerable latitude in making legislative choices, and EPA's
Choices in sort of what particularly to require, how to allocate that within, but a choice to say, great, you've demonstrated an emission limitation, an amount of pollution reduction that must be achieved. We're going to take that as just, you know, a rough recommendation. We're going to do something completely different. I know no case that takes that approach.
and of course, we're not saying we
Well,
can.
As long as we the state reasonably explain, well, you know, all our sources are all a little older than average, and, you know, this would be expensive. I mean, I take your position to be saying that EPA can't look at those things and second guess them because it's the prerogative of the state to take them into account.
I don't think they can second guess reasonable state judgments. And I think a state judgment that overrides EPA's industry-wide best system of emissions reduction determination with regard to that state is so if, for example, you know, a state said, well, all of our facilities are pretty average and, you know, we think that EPA considered costs incorrectly in their best system of emissions reduction, I don't think that would be permissible. But if a state says for this particular source, you know, EPA's representative data is not actually representative of this facility, and there are good reasons to, you know, choose a different system of emissions reduction or extend the compliance timeline, that should be within the state's reasonable discretion. And I think this is reinforced by the fact that in other provisions of the Clean Air Act, Congress was specific when it said that EPA's guidelines are mandatory and binding on the states. We pointed out the regional haze example, as explained by the Wyoming case in the 10th Circuit, and the Prevention of Significant Deterioration Program, where EPA's guidelines at times are explicitly mandatory. But I think when you're in this situation, which is much more similar to the BACT, Best Available Control Technology situation in Alaska Department of Environmental Conservation, or the state plan context in 110 of Union Electric and Train, state discretion is well established.
So what comfort can you give us, if we're inclined to agree with you, that, this is the quote from our Weyerhaeuser versus Kossel, that the pinhole safety valve envisioned by Congress doesn't become a yawning loophole?
I would be hesitant to describe state discretion as pinhole. And I think Weyerhaeuser involved a different situation where the statute did not explicitly allow variances, right? This is explicitly allowed in the statute. Nobody disagrees with that.
You're saying the statute provides a yawning loophole, and that's just the way it is, and it's always been.
Nor would I describe it as a yawning loophole. And I think there's a big gap between pinhole and yawning loophole. But I think states reason
for some comfort.
I'm happy to give that comfort. First of all, right, these regulations the old regulations were in place for a long time, and there wasn't necessarily yawning loopholes created. But second, just like the EPA is subject to arbitrary and capricious review by this court, states are subject to a certain level of arbitrary and capricious review by EPA. And we don't think that agencies, federal agencies, have yawning loopholes merely because they're subject to a reasonableness review by the court. I think the same is true of states. And, as I mentioned at the beginning, the EPA does get to determine the best system of emissions reductions, and state variances can't question those industry-wide determinations.
Mr. Manziotti, I mean,
In court, we can.
there's only a yawning loophole if EPA can set presumptive standards here. Nobody challenges whether EPA can set presumptive standards, and I'm wondering why that is.
In the American Lung Association case, we defended EPA's discretion not to set presumptive standards. I think to the extent that those presumptive standards are not binding on states, I'm not sure that there's any violation of the statute if they're guidelines. And of course, to a certain extent, right, they determine the emissions reduction available through the best system of emissions reduction.
Is that authority to set a presumptive standard?
I don't think it's necessarily, I don't think it's an authority to set a binding presumptive standard, but a presumptive standard where EPA says, like, look, we already looked at things, and if you happen to meet the presumptive standard, we're going to approve your plan, but not necessarily hold you to it beyond, again, the reasonableness review and the statutory compliance review we talk about. I'm not sure we have a problem with that. At the end of the day, while it's not a yawning loophole, I also don't think that EPA can take this discretionary provision that states have been granted by Congress and make it so tiny that it's practically nothing.
So how do we know whether what's EPA's latitude in evaluating whether a state plan's standard of performance reflects the degree of emission limitation and best system emission reduction that the EPA administrator has determined is demonstrated? If reflect doesn't mean match presumptively in a binding way, unless you can show, whether it's whether you can show something that's fundamentally different that allows you to depart from that. Then what is reflecting? What work is that doing?
I think reflect works hand in hand with the remaining useful life and other factors provision, in the sense that if the states all have no reason to impose something different on a particular facility beyond just disagreeing with EPA's, let's just say, affirmed best system of emissions reduction determination, I think that could be rejected as not reflecting EPA's determination. But if there are source-specific reasons to reasonably deviate from that, they don't have to match precisely one-to-one EPA's BESR determination.
Do you have any response to EPA saying, you say there should be reasonableness review? Of course, there's reasonableness review, but that's a far cry from fundamental differences. And I think their fallback argument is actually in the context of this process where we have considered a lot of this stuff, it's unreasonable to vary from it unless you've shown what they call a fundamental difference, something that is sort of new, wasn't taken into account, that would be the categorical description of the kinds of things that it would be reasonable for a state to rely on in departing from a full reflection of the degree of emission limitation that EPA found demonstrated.
I guess my response to that is that if they're not saying anything more than just reasonableness review, then you could excise that portion of the Code of Federal Regulations and their standard would be the same. And that's what we're asking you to do, to vacate the rule and take that out of the Code of Federal Regulations.
I think they're giving you context. They're saying, we're not going to see it as reasonable. So if you just said reasonable review, then it would be different from saying, let us give you some explanation of what we think is reasonable given the work that we've done, our role and your role. And they say, what would be reasonable would be if you point to something that's a fundamental difference from what we already considered. And so it just gives you more information, and it does narrow where reasonableness applies, but then once you're there, they're kind of saying it amounts to reasonable.
I don't think that's how EPA itself characterizes this regulation, and we're going off of how they've explained it in this rule and in other rules like the greenhouse gas rule and the methane rule. You know, I gave one example as the 95th percentile, example where that, I guess, to them is fundamental. Or if you take them at their word as saying, well, it has to be information that's fundamentally different. But if they considered cost, if they considered reliability, then that implies states can't consider those things in determining remaining useful life and other source. So I'm taking them at their word, and then maybe the sort of word that causes me the most heartburn is fundamental, right? That has to be fundamentally different, not just that there's a reasonable deviation available, but fundamentally different, something completely outside the scope of what EPA was considering.
Thank you.
Thank you, Your Honors.
Good morning, Mr. Hoshijima.
Good morning, and may it please the court. Suki Hoshijima for Respondents EPA. With me at counsel's table is Nora Greenglass from the EPA Office of General Counsel. The Supreme Court recognized just recently in the West Virginia case that EPA has the primary regulatory role under Section 7411D. Now, states do also have a critical role to play in the process. This rule appropriately balances the roles and responsibilities of states and the EPA. Now, unless the court—
Ask you about this, this line that EPA relies very heavily on this passing reference to the fact that EPA retains the primary regulatory role. I'm wondering, I mean, the Supreme Court has also in many contexts recognized a system of cooperative federalism under the Clean Air Act. And I wonder if EPA's reading of the Supreme Court's language here as the primary regulatory role, it doesn't just mean first here in this process of setting SIPs. I mean, EPA seems to read primary as meaning foremost or paramount or something like that. But maybe in context, it just means first. First the agency decides the amount of pollution, using the best system of emissions reductions, and then states then submit plans. So EPA is first, and then the states are second. It doesn't mean EPA has the most significant role in the system under Section 111.
We don't think that primary regulatory role refers solely to order here. One reason that's so is because EPA's role doesn't stop when it issues emission guidelines at the front end. EPA does make these nationwide regulatory determinations in which it determines how much pollution reduction is generally reasonable to require of the industry, but that's not the end of EPA's role. States then implement those determinations, but EPA, under subsection D2 of the statute, has the authority to determine if a state plan is satisfactory. Petitioners concede even that satisfactoriness review is a substantive review, at least for reasonableness. So EPA has the responsibility to make sure that state plans aren't undermining the emission guidelines and the initial regulatory determination that Congress assigned to EPA. Now, what EPA generally does in emission guidelines is it's looking at average and representative units in the source category to determine what is reasonable to require generally of sources. And in the second step, when states are turning that determination into standards that apply to specific sources, there's a translation step at which states get flexibility and are able to exercise discretion. States also are able to decide when, instead of just translating EPA's determinations, there's reason to deviate from EPA's emission guidelines. And this rule does give states a real and meaningful opportunity to deviate from EPA's determinations based on source-specific factors. EPA acknowledges that it's making broader nationwide regulatory determinations considering the industry as a whole.
Can you explain a little bit? Always helps me to have sort of more concrete sense of what's going on. When EPA is promulgating emissions guidelines for categories of existing sources. It says some on a nationwide basis.
Generally, yes, with the further caveat that EPA, when it finds some characteristics that are common to a subgroup of sources within a category, may subcategorize within emission guidelines.
But once it's decided, here's the set, then it does it for, it doesn't have like a separate guideline for every state. It does it for that set.
That's right. The emission guidelines are nationwide rules that EPA promulgates by looking broadly at what system of emission reduction is available and best for sources within that category.
And is the level typically set based on average facility in the category? Or, I mean, I know in some other EPA, they do, you know, the top, get rid of the best performing and then go for some subgroup below that. But here, average, median?
Well,
does it vary?
It's not what sources are already achieving on average, right? The relevant language is in subsection A1, where the standard is best system of emission reduction, and EPA looks at what systems are adequately demonstrated and what is achievable. So that may be a system that that the industry is not already using on a widespread basis, or that the average unit's not already using, but it may be a system that is nonetheless adequately demonstrated that results in a standard that is achievable and reasonably
And taking
achievable.
into account cost.
Yes, cost is a factor that the statute requires EPA to determine, to consider as part of that process.
So it could be that there's some relatively inexpensive, easy piece of equipment that all sources could use. None of them are using it, but it's been demonstrated that they could, and it's cheap. And so you could set a much more demanding, I mean, would that there were opportunities like this, but in theory, EPA could set a much more demanding standard than what's being achieved, because it could say this is demonstrated and achievable.
Yes, because absent a regulatory impetus, an industry isn't going to necessarily going to adopt the best system voluntarily, even one that is adequately demonstrated and even one that results in achievable emission reductions. That's the basic idea of Section 7411, is for EPA to determine what is reasonable to require of the industry generally.
So what does it mean to EPA for a state plan to be satisfactory? I thought the definition in the brief was, at least as I was reading it, was a little circular. It says that standards and state plans must be consistent with the statute. But I'm not sure that that helps us answer the question of whether the fundamental differences rule is consistent with the statute or not, as in one of the ways of implementing the EPA's satisfactoriness review.
EPA, yes, has understood satisfactory to mean consistent with the statute. In context, what that means, and we have to zoom out a little bit to explain what consistent with the statute means here. This is a statute where the Congress has assigned EPA to make these broader regulatory determinations. States have the opportunity then to deviate when there's something about a specific source that would make it unreasonable to apply those determinations to that source. So what this rule is saying, which is consistent with EPA's understanding of the statute for decades, is that it's not consistent with the statute for a state to deviate from EPA's emission guidelines and the determinations in them unless there's some difference pertaining to that specific source that makes it reasonable or makes it unreasonable to apply EPA's determinations.
I'm skeptical that this fundamentally different standard is continuous with EPA's long-standing interpretation. I mean, can you say a little bit more about that? I mean, one, those words seem to me, those phrases are very different, right? Significantly more reasonable versus a state has to demonstrate that there are fundamental differences. So the terms seem very different to me, maybe fundamentally different, we could say, but also the fundamental difference standard. So let me go back to the original rule, significantly more reasonable. That phrase only applied to other factors specific to the facility. And now in the revision to the rule, fundamental differences applies to all of the factors, including costs, physical impossibility, and the rest. So not only is the term broader, but its application seems to be substantially broader. So how is that continuous with what EPA has done in the past?
So let me start by discussing the relationship between this rule and the prior regulations, and then get to the application of fundamental differences to each prong. EPA explained that all it's doing here is clarifying what significantly more reasonable means. Now, I would focus the court's attention on the new version of the regulations, and this is in subsection E1 of the amended regulation, where even in this version, the touchstone is reasonableness. It says that a state can apply a less stringent standard if a facility cannot reasonably achieve the degree of emission limitation in the guidelines because of some of these factors. Reasonableness is also built into subsection E2 of the regulations, where, and that's where the fundamental difference language is, it says there has to be a fundamental difference such that achieving EPA's determination in the emission guideline is unreasonable for that facility. So we do think that reasonableness is actually still the core tenet of these regulations.
But basically, E2 suggests, to me at least, reading this together, that a state shows what it has acted reasonably by, a state must demonstrate that there are fundamental differences between the information that EPA considered and the facilities and information that the state considered. So the revisions to the rule defines reasonableness as putting a burden on the state to show that there are fundamental differences.
What this regulation is doing is, I think, giving a little more clarity about when.
You said that, but why is reasonableness now not defined as fundamental differences?
Well, the question is, when is it significantly more reasonable? That's the language under the prior regulations. When is it significantly more reasonable for a state to impose a less stringent standard? Well, it's significantly more reasonable when there's a fundamental difference between what is specific to that source and what EPA already considered in its nationwide determination, such that there's a reason to treat that source differently from everybody else in the category.
So, and then what about the application? So now a state has to demonstrate fundamental differences, not just with respect to other circumstances, but with respect to costs of control and physical impossibility. I mean, that is a substantial expansion, arguably.
And you're referring, Your Honor, to referring that language to all three prongs,
Yes.
right? So we don't think that's a substantive difference from what was there before. It's true that in the prior version of the regulations, the significantly more reasonable language was associated with other factors. We think other is the key there, where the first two prongs, unreasonable cost and physical impossibility, are instances of factors that would make it significantly more reasonable for a state to apply a less stringent standard, which is to say that the significantly more reasonable standard was always underlying all three prongs. It's just that textually it was associated only with this other factors residual clause. EPA thought in the process of revising this regulation that it would be clear to state more expressly what was already implicit there in that listing of the three prongs, and to say that fundamental differences is the basic idea that underlines each of those circumstances.
Historically, can you tell us a sort of general frequency, just give us a feel how often states invoke the remaining useful life of a facility to justify a less stringent standard of performance for existing sources?
In the preamble to this rule, EPA identified 4 historical instances in which states had sought to grant a source-specific variance. Now, that's not a large number, but we would posit that shows that states granting a variance is supposed to be the exception rather than the rule. States aren't supposed to come in and take EPA's determinations as just advisory, but then decide from the ground up what's reasonable to apply to sources generally. If
So in
EPA,
the other situations, they basically adopt EPA's guideline? Or are there other things that they do that change?
in the circumstances when a state doesn't grant a variance,
Or isn't taking remaining useful life of the facility into account?
in those
There are a lot of
situations,
other factors or,
a state has imposed standards that reflect EPA's emission guidelines. That doesn't necessarily mean, mirror precisely. States are able to impose a standard that achieves an equivalent level of stringency. So if a state already has a program that regulates sources in a way that is equivalent to EPA's determinations, then a state can make an equivalency showing.
I don't know if you can, and I know this is asking a lot of the lawyer rather than the agency staff, but can you give an example of, state already has stuff, EPA says, here's the best system of emission reduction, here's the resulting emission guidelines, state says, we can meet the overall amount that would be the same amount as if we applied your guideline, but we're doing what differently? I'm just trying to get a sense of even in the real world, what parameters are we even talking about?
I'm not sure I have a specific historical example for you, but there is a little bit more extended discussion of this in the methane emission guideline, where EPA in that preamble to that rule explained a little bit more about how it would conduct an equivalency determination. EPA set out basically a multi-step equivalency determination. Now, another way in which a state standard might reflect, not perfectly, but reflect an emission guideline in their standards without deviating from it would be, for example, an averaging or trading program, where a state can allow a group of sources to, in the aggregate, achieve the amount of emission reduction that EPA's emission guidelines would require. Of course, the extent to which a state is able to do that will depend on the nature of each emission guideline and characteristics that may be unique to each industry. So EPA in an emission guideline might provide further explanation of what kind of flexibility is available to states to implement emission guidelines without departing from them.
Can I ask you to maybe walk through EPA's arguments about why it claims it has statutory authority to recall and revise state plans? Because 111D1 says, gives EPA the authority to establish procedures under which states shall submit plans. So it's about regulations, procedures about submissions. And so once a plan has been submitted and approved, what authority does EPA have under 111 to take post-approval actions, like recalling a SIP or revising it?
In promulgating those two procedural mechanisms, EPA relied on both subsection D1 and subsection D2. Starting with subsection D1, Congress authorized EPA to prescribe regulations that govern how the existing source regulation process works. Congress specified.
Answer my question. So it says submit plans. How is a post-approval mechanism within that language?
Because the language about establishing procedures for submission is Congress specifying something that should be in those regulations, but there's not text saying that's the outside limit of the regulations.
Well, but other provisions have those specific authorities, to revise or recall plans. And that authority was not given in 111.
Right. Congress expressly conferred that authority to EPA in section 7410. In section 7411, Congress essentially used concise shorthand to say EPA given your experience administering these programs, we're going to give you the discretion to figure out which of those mechanisms from Section 7410 make sense to port over or to bring over as an analog in the context of Section.
What in the statute says that that part of Section 110 can be imported into 111?
Well, first, there's the language, just prescribed regulations to govern this existing source process. And also under subsection D.
It's not the existing source process. It's for submission of plans, to submit plans.
But it can't be that EPA's ability to promulgate regulations stops at the submission of the states, because that would mean that the existing regulations about how EPA considers, reviews a state plan, how EPA will promulgate a federal plan.
Because that's how they're reviewing the plan. They're reviewing the submission. And then after the approval of a SIP, there's no submission to be regulated.
But subsection D2 authorizes EPA to ensure that state plans are satisfactory. We're talking about
That's part of the approval process of a state plan. And so after EPA has determined a state plan is satisfactory, what regulatory authority does it have after that to later, maybe years down the line, revise or recall a state plan?
State plans are implemented over many years after the approval step. And we're talking about a situation where a state plan has become substantially inadequate. In that situation, it's no longer satisfactory. It's no longer achieving the pollution reduction objectives of the statute, because at that point, the state plan is no longer consistent with the statute. All EPA is saying here is that its authority to prescribe regulations for this process and to ensure the satisfactoriness of state plans allows EPA to establish what are just procedural mechanisms.
So it's just it can just decide whether something is satisfactory onto infinity, into the future, for all time?
Well, these are not new substantive authorities. These are procedural mechanisms for then EPA to determine whether a state plan is satisfactory.
So it just has like ongoing oversight authority to determine whether SIPs are satisfactory.
It does.
That's what EPA is essentially claiming.
Yes, because otherwise you would have state plans that are substantially inadequate, and there would be recourse that EPA would be able to take. For example, EPA.
Well, so what has EPA done in the past? Because this is a new authority that EPA is claiming. What did it do before this rule? When it thought a SIP was no longer satisfactory?
What EPA might do in the alternative will depend on the exact nature of the problem. Some options that EPA described in the preamble is that it may be able to use its enforcement authority under Section 7413 to enforce a state plan that a state is not adequately enforcing. EPA may also promulgate a new emission guideline that would require resubmission, but that's an incredibly cumbersome step that leads to the same place eventually. What this procedural mechanism does is to allow EPA to get to that place without having to essentially nationwide repromulgate an emission guideline and require all of the states to resubmit state plans.
So one of the reasons EPA says it needs this authority is if a state fails to implement the plan. Is that right?
Yes.
I thought that's specifically covered by 111D2B, where there's explicit authority of the administrator to enforce provisions of a plan if the state fails to do it. Is that different?
Subsection D2B authorizes EPA to take enforcement action, such as under Section 7413 to enforce a state plan.
But you're saying this is, if the state isn't enforcing it, that you could recall the plan and
direct the state to submit a plan that includes adequate state enforcement mechanisms, or else EPA would have to promulgate a federal plan that includes implementation of the emission guidelines and enforcement thereof. Because EPA coming in to federally enforce a state plan that a state is no longer adequately enforcing is a stopgap mechanism, but it doesn't actually solve the issue.
And it's a different kind of state-federal friction, so hopefully the states are going to be in cooperative federalism doing their own
Right.
work.
And so-
So this is a way of prompting the states to do the work
Yes,
rather than, marching in there to do it, the feds themselves.
and that's why EPA identified that as one of two types of circumstances in which it might use the state plan call authority. The other type of circumstance that EPA identified in this rule is when there's something that changes after an emission guideline and after approval of a state.
Can you remind me what an example would be of the change? I don't know, it says something like technical or,
Can be something technical. It can be a legal development. EPA explained in the preamble that there may be a variety of circumstances that make a state plan substantially inadequate. I do think it's important to point out that this isn't giving EPA a wide-ranging new substantive authority. It's a new procedural mechanism where states and regulated parties would also have recourse in terms of commenting on EPA's proposed state plan call, seeking judicial review of a state plan call or an error correction mechanism. We explained in our briefs that those are actions that EPA has taken in the Section 7410 context using those rulemaking procedures.
7410, Congress explicitly gave EPA those authorities,
Yes.
but they didn't in 111.
No, Congress did not expressly include those mechanisms in the Section 7411D process. Instead, it left EPA the room to decide whether those made sense to port over to this program.
in the rule, I'm sorry, did you want to follow up?
No, that's just not how we read statutes. I mean, if Congress gives a specific authority in one section, for one type of program, and then withholds it or doesn't explicitly provide it in the other section, the natural inference is that it doesn't exist in 111. Otherwise, that's normally how we read statutes. I'm not sure that you've explained how we would overcome that presumption.
Because Congress expressly linked Section 7411D to 7410,
But
And
not those parts of it.
Congress was writing Section 7411D in largely a bit of shorthand that refers back to 7410, authorizes EPA to establish procedures that are similar to Section 7410 when EPA decides it makes sense to do so. Again, any of these invocations of this authority are going to be judicially reviewable. At the end of the day, if EPA
That doesn't fix the problem that EPA may not have had the authority to exercise those procedures in the first place.
We submit that Section 7411D gives EPA that authority, where Congress entrusted to EPA the decision which of those elements made sense in this context.
You said it doesn't give them any substantive authority, it's just procedural. In the rule 6427A1, Romanet 1, the recall is appropriate when the applicable plan is substantially adequate to meet the requirements of the applicable emission guideline. Isn't substantially inadequate a substantive standard?
It's a standard for directing states to submit a new plan, but then EPA's review of that resubmitted plan is going to be under the same authority that EPA has to initially review a state plan.
And I guess to the extent that substantially and substantially inadequate does anything, it actually protects the state because it said can't be some nitpicky, technical, minor inadequacy. It has to be substantially, it has to be worth going back and reopening things.
Yes.
If, to meet that standard. So it's not like imposing a new standard on the state. It's actually saying, EPA, you didn't do this earlier. You can't be doing this with every little change in the world. But if it really becomes significant that it's legally or technically no longer meeting the requirements of the applicable emission guideline, then yes.
That's right. In a state plan call action, and the substantial inadequacy finding in it would be judicially reviewable. Now, if I may briefly address the timeline issue, as Judge Pillard recognized, in establishing the 18-month default state plan submission deadline, EPA was balancing competing considerations and paying heed to this court's American Lung Association case, where the court recognized that the central objective of the statute is to deal with the dangerous air pollution. Now, petitioners mostly focus on the historical data. And to make a couple of quick points about that data, we do think that data actually supports EPA's conclusion here. The data we're talking about is in a spreadsheet that's in the record. And that spreadsheet shows historically how long states have taken to submit state plans. EPA didn't look at that data and say, oh, there was one outlier state that managed to submit in 18 months. There's actually well into the double digits instances, historical data points of when states were able to submit in less than 18 months. Petitioners are faulting EPA for not taking the average, but the average just isn't the right metric. Because of this need for speed that the court identified in American Lung Association, EPA decided that it makes more sense to look at the minimum time reasonably necessary. And so if you're looking at the minimum time reasonably necessary, that's not the historical average. If the court has no further questions, we ask that the petitions be denied.
Thank you. I think we have one more interveners, 5 minutes.
May it please the court, my name is Matthew Grieco. I'm here from New York on behalf of the intervener respondents. The petition for review should be denied because EPA's rule is consistent with both cooperative federalism and under the best reading of Section 111D with the assigned roles of states and EPA. I want to start by explaining why the maximalist view of state discretion that runs throughout petitioner's brief is plainly incorrect, and then move to why EPA's specific regulation is valid. The text of the statute alone refutes petitioner's argument. And their first error comes in treating 111D1 as though it is primarily structured as a delegation of authority to states. The relevant statutory text here that they rely on regarding source-specific factors occurs in the midst of a sentence directing EPA to write regulations. And above and beyond that, by using the term standard of performance, it incorporates the definition of that term in Section 111A1 to mean a standard performance that reflects the degree of emissions limitation achievable using the best system of emission reduction that the administrator determines has been adequately demonstrated. So it is fundamentally a rule-making delegation to EPA with a proviso included in the midst of it that EPA exercise that delegation in a way that provides some mechanism for remaining useful life and other factors to be taken into consideration. And when Section 111D1 is properly understood in all of that context, it's clear why petitioner's reading of the statute has to be wrong. The statute not only permits but requires EPA, because it is a statute telling EPA to write regulations, to craft a regulation setting forth how remaining useful life and other factors may be considered. The petitioners want this court to read a sentence that expressly delegates rulemaking authority to EPA in such a way that EPA has no authority to set contours for how remaining useful life is taken into consideration. And for example, at page 15 of petitioner's brief, they argued that the statute places no limits on state authority other than the reasonableness that applies to all rulemaking. But that essentially reads the rulemaking role for EPA out of the statute. And there are several other features of the text that further confirm EPA's reading is correct. The best reading of the phrases shall permit and take into consideration is that the thing to be considered must receive a meaningful evaluation as a part of the process, not that it will be dispositive in every case. And in addition to that, we have the word satisfactory in the statute, making clear that EPA's role is to review whether the state plan is consistent with EPA's guidelines, and rule-off is meant to be an adjustment to that. In addition to the statutory text, the Supreme Court's holding in West Virginia versus EPA could not have been more clear in stating that the agency, not the states, decides the amount of pollution reduction that must ultimately be achieved. That is in addition to the language that received some attention earlier about EPA having the primary regulatory role. I do want to say that on the question of the meaning, what the Supreme Court meant by primary regulatory role, I don't think it can mean simply that EPA starts the process at first and then it is handed over entirely to the states. A better way to understand it is that the states operate in the middle of the process, that EPA adopts its guidelines, states propose plans, which may in some cases involve a rule-off determination, and then it proceeds to EPA satisfactory review. And
Can you back up for a moment? You went rather quickly through shall permit, taking consideration, meaning it gets a meaningful consideration, and satisfactory. Focusing on shall permit, I mean, your sister states have said that shall permit means must permit. And your response to that is?
the response to that is that it means that it shall permit them to take it into consideration. And the error lies in believing that take into consideration means that in every case, a source-specific factor is going to have is going to be outcome determinative. Take into consideration means that the process provides a meaningful way to ensure that source-specific factors are not overlooked during the course of the regulatory process.
And in their view, that they can affect the bottom line. I mean, take into consideration is window dressing if it can affect the bottom line.
And in some cases it can, and it needs to be a meaningful review process. But the petitioner's brief suggests that once a state has made a determination that remaining useful life or other factors ought to apply, the EPA has to, in all circumstances, treat that as outcome determinative. And that's not what the statute says. And the statute, to the contrary, says that EPA is to set a set of procedures for determining how states shall be permitted to take this into consideration. So if a state has the opportunity to present its arguments for a variance based on remaining useful life or other factors, EPA is still within its delegated authority under the statute to set the regulation that it has set here, explaining what showing needs to be made in order for that to be attained. And
so what is your understanding when you say a set of procedures, that seems like arguably, maybe West Virginia would say, hiding something that's anything but procedural. You're saying not just when you take it into consideration, that you have a moment to do that, but limitations on how you take it into consideration.
well,
And, I think EPA is kind of saying, no, take it in consideration, and we're really subject to reasonableness review. But I guess you could say it's procedural in the sense that it only trains on things that haven't already been accounted for. I don't know. Help me out with why your characterization of EPA's role as setting procedures for how that's taken into consideration. Why isn't that just three-card Monte putting a EPA's substantive restriction into procedural garb?
well, a couple of things. I mean, I first of all would point to the fact that the regulations have historically, ever since the original implementing regulations in the 1970s, included substantive requirements for what needs to be shown in order to make a remaining useful life and other factors determination. And in fact, the 2019 regulation retained those original implementing regulations with only minor wording changes. And many of the states who are petitioners here today defended that 2019 regulation by arguing that it simply repeats the statutory language. And the contribution that EPA has made here pursuant to its statutory delegation is that it provides additional clarity. As my friend from EPA was explaining, it provides needed context for what a state needs to show in order to make a rule-off determination. And as states, we support a clearer rule because clarity in what showing is required for a variance supports transparent application of EPA standings.
And your understanding, if we were to invalidate this, is that it would roll back to the 2019, or the 2019 by its terms doesn't apply? 2019 standard that you just alluded to.
I think it would roll back to the original regulations.
74.
Right. Yeah, well, but even if the consequence were that it would restore the 2019 regulation, which required factors for a less stringent standard to be significantly more reasonable, a rule that not only went unchallenged by the petitioners, but which many of the petitioners intervened to defend, the delta between that rule and this one is comparatively small. I also want to point to this court's decision in the Weyerhaeuser case, which demonstrates the longstanding familiarity of this court with the term fundamental difference. And it refutes the idea that because EPA requires a showing of fundamental difference, that the fact that any information has been considered as to a particular topic rules out a variance under remaining useful life and other factors. And the court clearly understood in that case that if a factor was considered but is present to a fundamentally different degree, that can support a variance. And EPA, in adopting the current regulation, did not choose the words fundamental difference coincidentally. And I also want to emphasize that we should want EPA to set a standard that provides a lot of clarity for when a remaining useful life and other factors determination is appropriate. Because Congress wanted EPA to be meticulous in its original approach in developing the guidelines. It is reasonable to require a showing that something fundamentally different was not considered in order to obtain that sort of variance. And Weyerhaeuser also makes clear that when Congress puts a safety valve into a statute, EPA is not required to interpret that safety valve as a yawning loophole. Petitioner's interpretation would prioritize the safety valve over the emission guidelines itself, which is not consistent with the text of the statute and is certainly not consistent with an understanding of how the regime works that was viewed by the Supreme Court as uncontroversial in issuing its decision in 2022.
Right.
Just to briefly talk about the timeline issue, the starting point on the timeline issue has to be that EPA has to engage in some sort of balancing in order to arrive at a timeline. As Judge Pillard said during one of the earlier arguments, there are conflicting exigencies. And so once you accept that there has to be some degree of balancing, the question is whether EPA reasonably cited to a basis for the deadline that it chose. And as my friend from representing EPA said earlier, there are a significant number of states that have been able to meet the 18-month deadline in the past. And the spreadsheet that is linked at page 104 of the joint appendix reflects that. So that shows that it's attainable, and it's reasonable for EPA to set a deadline that is consistent. It can choose something that is at the shorter end of what states have been able to attain in the past, because the statute contemplates that EPA is intended to move the process along to some degree.
Okay.
Thank you.
Thank you. Now, did Mr. Mansinghani reserve time for rebuttal? 3? Okay.
Thank you, Your Honors. A couple of quick points. When I heard my counsel on the other side reference what is when variances are allowed, he says, well, if the information is different, that makes it more reasonable. And he omitted the word fundamentally, because I don't think you can utter the word fundamentally and say this is just the same thing that's been going on all along. Now, they point to this primary regulatory role language in West Virginia, but I think, Judge Rao, you have it right that in a certain sense that it's that EPA acts first, but also that they set the default in terms of making the generic technical determinations about feasibility and reliability and cost. And that is one of the 3 things we think binds states' discretion, in that they get to make that initial determination. The rule-off, the remaining useful life and other factors determinations by states have to be consistent with the statute and reasonable. So I hardly think that this is unbounded.
Can I just interrupt you on the error correction and recall piece? Your argument, I gather, is that they're not listed in section 111 or section 110C, so not authorized. But there are the three other authorities, partial approval, conditional approval, and parallel processing, that also aren't listed, but those aren't challenged.
So I think all of those relate to the state plan submission process, and it's within their 111D1 authority. And, you know, so yeah, I guess that would be my answer to that.
I guess, yeah, so you're just saying it's temporary, that even though in some sense, certainly the error correction can be said to relate to the state plan submission. EPA says, we made a mistake in, you know, accepting your submission. We should have told you to do this or that, or we just added something up wrong, or, you know, so.
It is partially temporal, yes, in the sense that this is relating to the state plan submission and approval process that comes in D2, but it's not a post-approval thing like error correction or calling for plan revisions. The post-approval authority, as you pointed out, is explicit in the terms of failure to implement plans and aligning it with sections 113 and 114 of the Act. And I think for all of the reasons that were given in the questions by Judge Rao, I think that issue is pretty clear. And so the last thing I want to touch on before my time expires is on the timing issues. I think the real problem here is that they did a lot of work in collecting data and telling states, give us comments about how long state procedures will take. And then they did not at all, at least in the face of the rulemaking, consider that in terms of setting 18 months. The only justification for setting 18 months was this cherry-pick statutory comparators. When it comes to the data, they didn't say anything about how that, what they're saying now about, well, enough states submitted their plans within 18 months is not in the rule.
Didn't they move from 15 to 19 based on that data?
They moved from 15 to 18 based on that data, but they never provided any explanation for why 18 was enough as opposed to something higher. Or they moved, I would say, from 9 to 18. I think the 15 to 18 was based on the meaningful engagement requirement.
Right.
And when it comes to
They doubled it based on that data, and you're saying they didn't explain why they didn't just accept it wholesale?
well, I think they didn't explain why they chose 18 from that data. What they're saying now is enough states, met 18 is nowhere in the rule. And so in a certain sense, going on with the failure to consider the state comments as to how long state procedures take, that's an arbitrary and capricious decision for failure to consider the record evidence, but it's also a failure to respond to comments because all they had was ipsa dixit that, well, we reviewed the steps states need to carry out. That's at Joint Appendix 45. You won't find any other explanation of how they accounted for that factor.
Just on the issue of arbitrary and capricious, the whole argument about the EPA's ability to, I guess, cabin the state's use of reasonably consider source-specific factors. What I see in your brief that's developed is an excess of statutory authority argument. I don't really see developed an arbitrary and capricious argument. Did I miss that?
I think that's correct, Your Honor. It's primarily that this is outside of their statutory authority. I don't believe with respect to this issue, we made an arbitrary and capricious argument.
All right, thank you.
Thank you, Your Honors.
Thank you. The case is submitted.
This honorable court has stands adjourned until Tuesday, January 21st at 9:30 a.m.